This is AM 650's The Law Show with Sterling Fox. Now back to the show.
Nice to have you with us this Sunday morning. We're talking with David Hobbs and Ian Giroday from the Vancouver estate litigation firm, Hobbs Giroday in downtown Vancouver. Right down there, is it Howe Street, Ian?
It is.
On right opposite the courthouse. Online, by the way, friends, at hobbsgiroday.com. Giroday, by the way, spelt like that famous ex-BC Lion guy, Giroday. And yes, Ian is Paul's cousin. So we were talking about trusts and joint bank accounts. There's another part of it. We're talking about estate planning and how to organize one's life to avoid, these conflicts that our specialist friends at Hobbs Giroday see all too often, and that is the whole matter of people attacking or challenging the conditions of a will. One of the things that most of us have, to one extent or another, guys, is typical stuff like RSPs and life insurance policies and pensions. Where does that factor into the estate? Now, for example, if I die, my wife is my beneficiary. It's plain as a nose on my face. It's right there on the policy. There's no dispute about that. Is that taxable within my estate, Ian, or is that a separate file? How does all that traditional stuff that most of us have, how does that get resolved?
Right. So if there's a beneficiary designated in an RRSP or a RIF or a life insurance plan,
right,
or life insurance policy, or a pension, that doesn't flow into the estate. That goes to the beneficiary outside of the estate.
Okay.
Again, though, we're looking at is there any reason to believe that designation is impressed with the trust in some fashion, and it was the RSP given to the executor with some understanding that it would be distributed to all of the children or anything like that. But generally speaking, it doesn't fall into the estate. You don't pay probate fees on it, and it at first blush it appears to be a gift.
Okay.
Another maybe interesting to the listeners aspect of this discussion is we were talking about wills variation and a person who feels they've been unfairly dealt with in a will. Mm-hmm. You can look at the assets that other people have received from other sources, such as life insurance or RSPs or gifts during lifetime, and you can weigh those assets and the value of them in the discussion of the fairness of the will.
Okay.
So you can say, hey, you got the $1 million life insurance policy. I didn't get that. Mm-hmm. We need to balance that in our discussion about the variation of the will.
Mm-hmm. But what if the will maker had intentionally wanted an imbalanced outcome? They had wanted one child to receive more than the other child because they had their reasons. They've lived with this person they gave birth to that person. They have pretty clear-cut reasons why one child is to be favored in the state over the other one. What do the courts do, Ian, when the will maker puts down in writing, I want X left to this child and Y left to the second child, an inferior number, and here's why. A clear reason for that the child receiving the short end of the stick comes to you guys and says, wait just a second, this is outrageous. What happens? How do the courts look at that?
Well, the wills variation claims are brought pursuant to a written law, BC law, called the Wills Variation Act.
Okay.
There's a section of that act which specifically directs the court to consider the reasons why a will maker has made the dispositions they have or gifts they have under their will.
Right.
And the reasons, if they're stated, pardon me, I shouldn't say if they're stated, because it can be either written reasons or any other type of evidence that the court deems appropriate.
Okay.
But they can look at reasons why they have not left anything to a spouse or child or left less. So that is evidence that the court will entertain in deciding what's fair in all the circumstances.
Right. And if for example, David, there was a perfectly valid reason why one beneficiary was favored over another and a lopsided amount is awarded to one person versus the other, if there's a perfectly good reason for that by the person with all the dough who does the leaving, will the court go, okay?
Well, one thing I think we should add to our discussion is that spouses and infant children, i.e. under 19, the testator owes those category of people who can complain under the wills variation. They owe them a legal duty. And the concept of legal duty is sort of akin to family law. So my spouse, we have family assets, and I have a legal obligation.
Okay.
Or an infant child, I have an obligation to care for that child because that's my child, and they're an infant, and I have a legal obligation. So these kinds of legal obligations apply to those people: infant children, spouses, adult children. Do not have, there's no legal obligation. I, as a parent, have no legal obligation to look after Johnny, who's 40 years old or 50 years old. The law doesn't require me to do that. I can kick him out the door when he's 19 and say, good luck and hope life is good to you. So that category of child only gets a moral obligation, i.e. so what they're arguing is they're saying, when dad or mom left me 5% of the estate and all the other kids got 50% or 20%, he or she didn't satisfy the moral obligation. And the rational reasons can be things as simple as having lent money to that child and it never having been repaid during the lifetime. They can say, well, I made a lot of loans to one child, not the other. That'd be rational.
Right.
If the person says, well, I really didn't like the checkered shirt he wore all the time, and that's why he's out of the will. I told him to get a haircut or whatever.
If it's frivolous.
Not rational, not valid, not going to be upheld by the court. And the court's looking for valid and rational reasons for disinheritance, and more importantly, they're looking for the evidence of it. Hopefully it's in the lawyer's file, a note of it, or something that everyone can understand what the reasoning was.
Okay. Ian, did you want to add anything to that?
I guess the only thing I'd add to that is validity and rationality in the circumstances is judged upon contemporary British Columbia society, in effect.
Okay.
So if the reason for differentiation between your children is based on sex or sexual orientation,
right?
The courts won't find that as a valid and rational reason to treat them differently under the will.
And this opens the door, and you're doing it again, to an issue that we've actually talked about together on this program in the past, and that's the whole matter of a will maker with, say, a substantial estate, enough money to have an impact on people's lives, decides, just to carry on further to what you were just saying, David, a parent decides to punish a child in their 40s. The child I'm talking about in their 40s. Mom's 85. There's been a dispute. This has been festering for decades. And I'm going to get the last shot in. When my will is read and the family is gathered around in the lawyer's office, somebody's going to get just a real whacking from me, and the lawyer's going to have to read it out in front of everybody, and that's my last shot at that little creep. And I mean, probably I'm being a little dramatic, but this wouldn't be the first time this notion has crossed your desk. I can tell by your expression, Ian.
Well, I guess the first thing I would say is the idea of the family gathering in front of the old family lawyer and getting the will read out loud.
A little dated, perhaps?
Well, you see that in movies and television perhaps more than reality.
Okay.
There's no obligation to do that.
All right.
That being said, you're absolutely right. I think that there can be sort of the notion of I get the last shot as I pass on to the other world.
Right.
And again, you're looking at things like perhaps alienation. I'm leaving Johnny nothing under my will because he barely ever picked up the phone, never acknowledged my existence for the last 20 years, and so on and so forth. As wills variation lawyers, we're looking at what was the reason for the alienation? Is it all the fault of one side? Did they both share blame in it? Was it more the fault of the will maker?
Right.
So that's sort of.
And so you would have to unravel that and then prove it to the court, right?
Right. Exactly.
Okay. And so I would imagine in some cases the attempt to punish a child on your deathbed fails.
Well, I would point out, Sterling, that sometimes the last shot of before I leave the next world is my last fib, not my last true statement.
Right.
We get very unusual situations sometimes where you're discussing alienation, and the person says, well, the person used to beat me or sexually assault me,
Right.
and they're pretending that I ignored them, but there was a reason. So you get into sometimes some very troubling family history that has to be sorted out.
And keeping in mind that when these are pretty delicate matters, and there's always two sides to every story.
Well, and all the other relatives who either confess to know or not know anything about such an outrageous idea, whatever it might be.
Interesting stuff on the Law Show this Sunday morning. Nice to have you with us on December 1st. David Hobbs and Ian Giroday from Hobbs Giroday here in Vancouver are our guests, and we'll be back with our final segment right after this.
There's more of the show still ahead. This is AM 650's The Law Show.